This week, President Trump fired two Democratic members of the Federal Trade Commission, the agency responsible for policing big business and protecting consumers. Alvaro Bedoya and Rebecca Kelly Slaughter were dismissed before their 7-year terms were up. The Trump administration has yet to provide any justification for the firings, and both Bedoya and Slaughter are now suing, alleging that their dismissals were illegal. The FTC has traditionally been a bipartisan commission consisting of 5 commissioners with no more than 3 from one political party at any given time. It is designed to be an agency somewhat independent from the executive, and Trump's firing of the 2 Democrats is being seen as a rejection of that independence and an assertion of power over the agency. When Trump took office, he appointed Andrew Ferguson to chair the commission, effectively demoting the former chair, Lina Khan. She resigned from the commission shortly thereafter. But under Khan's leadership, the FTC had been leading an ambitious antitrust agenda.
Okay, so this is a story about what happens when a president who has been firing independent agency heads left and right as part of his deep state purge suddenly runs into the one institution that even he cannot bully or ignore or simply steamroll through with bluster and threats, the Supreme Court, and watches as even a conservative majority he helped create signals that there are constitutional limits to executive power that he may have crossed in his aggressive rush to seize control of the entire federal bureaucracy. The Supreme Court just handed Trump a stinging and complicated defeat by staying a lower court order that had blocked his mass firing of Federal Trade Commission Chair Lina Slaughter, but simultaneously fast-tracking a case that could gut 90 years of established precedent protecting independent agencies from presidential control and exposing the full scope of his unprecedented purge strategy to the highest level of judicial scrutiny. Trump has been raging on Truth Social about rogue activist judges sabotaging America first, but the emergency ruling exposes his rush to fire protected officials without any cause and is fueling bipartisan fears that his aggressive power grabs have crossed into genuinely authoritarian territory that threatens the constitutional structure itself. But before we go any further, real quick, let's be honest, you can't really trust mainstream media anymore. That's why we built Pump Politics, to bring you real stories, real context, and no corporate spin. If you want to stay ahead of the headlines, join our free newsletter. We'll send the news straight to your inbox every day. Just click the link in the description to join. And if you just want to support what we're doing, join us, be part of the community that actually cares about the truth. All right, let's get back to the video.
We talked a few weeks ago, and so much has happened since then, including the firing of your former colleagues at the FTC. This is unorthodox on a lot of levels. They have terms. They're not supposed to be fired in between their terms. And there's been an understanding of a sort of a relative party balance in this agency and independence from the executive. All of that got smudged away.
This is blatantly illegal. That's the first thing to know, that the law is crystal clear that commissioners can only be fired if they do something egregiously wrong.
Right.
If they engage in malfeasance, neglect of duty, some type of inefficiency. So there's no gray zone here. What the administration is trying to do by firing them violates the law. To me, though, the bigger question is, why do this?
Right.
Right? I mean, the commission is now run by a Republican chair.
Right.
They're going to imminently have a Republican majority.
Let me walk you through exactly what the Supreme Court did and why this ruling represents both a short-term procedural win and a potentially devastating long-term threat to Trump's entire approach to controlling the federal government, because understanding the legal complexities here is absolutely essential for grasping why D.C. is panicking and why this case could reshape the balance of power between presidents and independent agencies for generations to come. On September 22, 2025, the Supreme Court granted Trump's emergency application in the case Trump v. Slaughter, blocking the reinstatement of FTC Chair Slaughter that a lower court had ordered after finding Trump's firing violated established law protecting independent agency heads from removal without cause, as Congress specifically intended. But here's the part that should terrify Trump's legal team even as they celebrate the short-term stay. The court simultaneously fast-tracked the underlying legal question for full argument in December 2025 by granting certiorari before judgment in an extremely unusual procedural move. This means the justices are going to decide whether to overturn Humphrey's executor, the landmark 1935 Supreme Court precedent that has protected independent agency heads from presidential removal for 90 years, with a full hearing and briefing and oral argument in a definitive ruling rather than letting the question linger in lower courts for years. If Trump wins that argument, he gets virtually unlimited power to fire anyone in the executive branch, regardless of what Congress has said. But if he loses, and the dissent suggests at least 3 justices think he absolutely should lose, his entire purge strategy collapses spectacularly, and every firing he has conducted could potentially be reversed. Justice Elena Kagan wrote a blistering and pointed dissent, joined by Justices Sotomayor and Jackson, that signals just how extraordinarily high the stakes are in this case and how seriously the liberal justices view the threat to constitutional structure. Kagan wrote that the emergency docket should never be used to reshape the separation of powers, arguing forcefully that the majority is giving the president unlimited removal power that Congress specifically and deliberately denied when it created independent agencies with for-cause removal protections. This dissent matters enormously because it provides the legal framework for challenging Trump's purges going forward, and because it signals that at least 3 justices see what Trump is doing as a fundamental threat to the constitutional structure of American government rather than a legitimate exercise of executive authority. The scope of Trump's purge has been extraordinary and completely unprecedented since he returned to office in January 2025. He fired Slaughter at the FTC without providing any cause as required by the statute Congress enacted. He fired the heads of the Consumer Product Safety Commission and the Merit Systems Protection Board and the National Labor Relations Board, all agencies where Congress specifically provided that heads could only be removed for cause rather than at presidential whim. Trump claims broad Article I power to remove any executive branch official, regardless of what Congress has said about removal protections, but this aggressive claim directly contradicts decades of Supreme Court precedent and the specific statutory protections Congress deliberately enacted to insulate these agencies from political pressure. The D.C. District Court that initially blocked Trump's firing of Slaughter found that his actions violated established law and ordered her reinstatement to her position. Trump's emergency application to the Supreme Court asked the justices to stay that reinstatement order while the underlying legal questions were resolved through the normal appellate process, and the court granted that stay in a 6-3 decision along ideological lines. But granting a stay is absolutely not the same as ruling on the merits of the case. It simply maintains the status quo while the case proceeds through full briefing and argument. And the fact that the court immediately fast-tracked the case for full argument suggests the justices understand they need to provide definitive guidance on presidential removal power rather than letting chaos reign while lower courts across the country reach conflicting conclusions. Trump's true social eruption about rogue activist judges reveals his deep frustration at encountering limits on his power that he cannot simply bulldoze through with the aggression and bluster that has characterized his approach to every obstacle. He has spent his entire political career treating legal constraints as temporary obstacles to be overcome through sheer force of will rather than boundaries to be respected and worked within. But the Supreme Court is different. Even with a 6-3 conservative majority that he largely created through his appointments, the justices have shown repeatedly they will not simply rubber stamp everything Trump wants to do, regardless of constitutional constraints. All right, so let me walk you through in much more detail what the Supreme Court actually did in this case and why the legal questions at stake could reshape the relationship between presidents and independent agencies in ways that have profound implications for how the federal government functions and has functioned for nearly a century. Because understanding the specific legal issues and the historical precedent they are built on is essential for grasping why this case matters so much and why Trump's celebration of the short-term stay may be dangerously premature. Humphrey's Executor v. United States was decided by the Supreme Court in 1935 and established the constitutional foundation for independent agencies that has governed American administrative law for 90 years through Democratic and Republican administrations alike. The case involved President Franklin Roosevelt's attempt to fire a federal trade commissioner named William Humphrey without providing any of the causes that Congress has specified as grounds for removal, and the Supreme Court unanimously ruled that Congress could constitutionally create agencies whose heads were protected from presidential removal except for specific causes like inefficiency, neglect of duty, or malfeasance in office. The decision recognized that some government functions benefit from being insulated from direct presidential control and political pressure, allowing experts and professionals to make decisions based on evidence and law rather than the shifting winds of partisan politics. This landmark precedent has been the foundation for the entire structure of independent agencies that regulate crucial aspects of American economic and social life. The Federal Reserve, that controls monetary policy and interest rates affecting every American. The Securities and Exchange Commission, that regulates financial markets and protects investors. The Federal Communications Commission, that oversees telecommunications and broadcasting. The Federal Trade Commission, that enforces antitrust law and consumer protection. All of these agencies exist in their current form because Congress decided their important functions should be somewhat insulated from direct presidential politics and pressure, and Humphrey's executor has protected that deliberate insulation for 9 decades across every administration, regardless of party. Trump's legal theory is that Humphrey's executor was wrongly decided from the beginning and should be overturned after 90 years. That Article 2 of the Constitution gives the president complete and total control over the entire executive branch, including the absolute power to remove any official for any reason or no reason at all, regardless of what Congress has said about removal protections. This aggressive theory has been advanced by conservative legal scholars associated with the unitary executive movement for decades and has gained significant traction on the current Supreme Court, which has shown notable skepticism toward independent agencies in other legal contexts. If the court accepts this sweeping theory, it would give presidents virtually unlimited power to control every aspect of federal administration and would completely eliminate the independence that Congress specifically and deliberately designed these agencies to have. The specific case of Trump v. Slaughter involves FTC Chair Lena Slaughter, who Trump fired shortly after returning to office in January 2025 without providing any of the causes that the FTC Act specifically requires for removal of commissioners before their terms expire. Slaughter was appointed to a term that had not yet expired and was entitled under the statute to remain in office unless she was removed for one of the specified causes Congress had established. Trump simply ignored the statutory requirement entirely and fired her as part of his broader purge of officials he viewed as deep state obstacles to his America First agenda. Slaughter sued in federal court, arguing the firing violated the statute Congress enacted and the constitutional precedent of Humphrey's executor that has stood for 90 years. The D.C. District Court agreed with Slaughter after full briefing and argument and ordered her reinstated to her position, finding that Trump's firing violated established law and that he did not have the constitutional authority he claimed, regardless of how broadly he interpreted Article 2. This ruling put Trump in the position of either complying with the court order and reinstating someone he had publicly fired or seeking emergency relief from higher courts to block the reinstatement while he appealed. He chose to seek emergency relief from the Supreme Court, and the court granted a stay of the reinstatement order while simultaneously agreeing to hear the underlying legal question on an extremely expedited basis. The 6-3 vote granting the stay followed the expected ideological lines, with the 6 conservative justices appointed by Republican presidents in the majority and the 3 liberal justices appointed by Democratic presidents dissenting. But the fact that it was only a stay rather than a summary reversal on the merits suggests even the conservative justices are not ready to simply declare Trump the winner without full briefing and oral argument on the complex constitutional questions involved. The simultaneous grant of certiorari before judgment, meaning the court will hear and decide the case before the appeals court has even ruled, indicates the justices understand the urgency and profound importance of providing definitive guidance on presidential removal power. Justice Kagan's dissent is extraordinarily significant because it provides a detailed roadmap for how the liberal justices will argue the case on the merits and because it frames the stakes in the starkest possible constitutional terms. She wrote that the emergency docket should never be used to reshape separation of powers, sharply criticizing the majority for using an expedited procedural posture that limits briefing and argument to make what could be a transformative constitutional decision affecting the structure of American government. She argued the majority is effectively giving the president unlimited removal power that Congress specifically and deliberately denied when it created independent agencies, a direct and forceful challenge to the unitary executive theory that Article 2 overrides all congressional decisions about agency structure and removal protections. The dissent also emphasized with considerable force the practical damage that could result from the court's intervention and the legal uncertainty it creates. If Trump's firings are ultimately upheld on the merits, the decisions those fired officials made while in office could potentially be challenged as invalid because they were made by officials who should have been removed. If his firings are ultimately struck down, the decisions made by their replacements Trump installed could be challenged as invalid because those replacements were unlawfully appointed to positions that were not actually vacant. The legal uncertainty created by the court's emergency intervention affects not just these specific officials, but the entire functioning of the agencies they lead and the businesses and individuals and markets those agencies regulate. The broader context of Trump's unprecedented purge makes the stakes even higher than this single case might suggest. Since January 2025, Trump has fired not just Slaughter at the FTC, but the heads of multiple other independent agencies, the Consumer Product Safety Commission that protects Americans from dangerous products, the Merit Systems Protection Board that protects federal workers from political retaliation, the National Labor Relations Board that enforces labor law and protects workers' organizing rights. Each of these firings rested on the exact same legal theory that Article 2 gives the president unlimited removal power, regardless of what Congress has enacted. If the Supreme Court rejects that theory, every single one of these firings could be reversed, and every action taken by Trump's replacement appointees could be challenged in court. The connection to the Doge purges and Elon Musk's controversial data operations adds another troubling dimension to the constitutional controversy. Trump's aggressive effort to control independent agencies is part of his broader declared war on the federal bureaucracy that has involved not just firings of agency heads, but also massive restructuring and data collection, and what unions have characterized in lawsuits as illegal access to private information about federal employees and the Americans they serve. The American Federation of Teachers and other unions have sued over what they describe as unprecedented and illegal hacking of Americans' private data as part of the supposed government efficiency drive. The Supreme Court case is the legal tip of a much larger spear aimed at dismantling long-established protections for federal workers and federal agencies. The tariff litigation provides yet another connection that could multiply the impact of adverse Supreme Court rulings on executive power. In November 2025, the Court of International Trade ruled that Trump's use of the International Emergency Economic Powers Act to impose sweeping tariffs was illegal and exceeded his statutory authority, a decision that, if upheld on appeal, could require refunding well over $100 billion in tariffs that have already been collected from importers and passed on to American consumers. If the Supreme Court signals skepticism of Trump's aggressive and expansive interpretations of executive power in the agency removal context, that judicial skepticism could significantly influence how courts approach other challenges to his broad legal theories across multiple policy areas. Okay, so let us break down exactly what this Supreme Court action means and why Trump's eruption about rogue activist judges reveals how seriously this legal challenge threatens his entire approach to controlling the federal government and purging officials he views as deep state obstacles to his agenda. Point number 1. On September 22, 2025, the Supreme Court granted Trump's emergency stay in Trump v. Slaughter, blocking the reinstatement of FTC Chair Slaughter while simultaneously fast-tracking the case for December 2025 arguments on whether to overturn Humphrey's executor, the landmark 1935 precedent protecting independent agency heads from presidential removal for 90 years. Point number 2. Justice Kagan's blistering dissent, joined by Sotomayor and Jackson, argued the emergency docket should never reshape separation of powers, and accused the majority of giving the president unlimited removal power that Congress specifically and deliberately denied when it created independent agencies with for-cause removal protections. Point number 3. Trump has fired heads of the FTC, CPSC, MSPB, NLRB, and other independent agencies without any cause since January 2025, claiming broad Article 2 power that directly contradicts decades of Supreme Court precedent and the specific statutory protections Congress enacted to insulate these agencies. Point number 4. The case tests Trump's aggressive theory that the president has complete control over the entire executive branch and can remove any official for any reason, a theory that, if rejected, would potentially reverse every purge firing and challenge every action taken by replacement appointees. Point number 5. Trump raged on Truth Social about rogue activist judges sabotaging America first, revealing his deep frustration at encountering judicial limits on power he cannot simply bulldoze through with the aggression and bluster that has characterized his entire approach to governance. Point number 6. The connection to Doge data operations and Musk purges shows this Supreme Court fight is part of a broader war on the federal bureaucracy that unions have challenged as involving unprecedented and illegal access to private information about Americans. Point number 7. The Court of International Trade ruled in November 2025 that Trump's use of IEEPA for tariffs was illegal, a decision that could require refunding over $100 billion, and that signals growing judicial skepticism of aggressive executive power claims across multiple policy areas. Point number 8. Birthright citizenship injunctions add yet another front where courts are blocking Trump's unilateral executive actions, creating a clear pattern of judicial pushback that threatens his entire governing approach based on expansive claims of presidential authority. Point number 9. If the Supreme Court ultimately rules against Trump on agency removal power, his entire purge strategy collapses, and the chaos created by firing and replacing officials could generate years of litigation over which decisions made during this period are actually valid, enforceable. So where does all of this leave Trump as he faces the very real possibility that his signature strategy of purging the deep state could be declared unconstitutional by the very conservative Supreme Court he helped create through his 3 appointments? The situation is genuinely dangerous for his entire agenda because, unlike political opposition that he can attack and bully and overwhelm, judicial rulings require compliance that he cannot simply refuse without creating a constitutional crisis of unprecedented proportions. The fast-tracking of the Humphreys executor question for December arguments means Trump will get a definitive answer relatively quickly about whether his sweeping theory of presidential power is constitutionally correct. If he wins the argument, he gets confirmation that he can fire anyone anywhere in the executive branch and achieves complete control over independent agencies that have historically been deliberately insulated from presidential politics and pressure. If he loses, every single firing he has conducted is potentially reversible, and the officials he installed to replace the people he fired may have their decisions challenged as invalid because they were unlawfully appointed to positions that were never actually vacant. The irony that should not be lost on anyone is that this Supreme Court exists in its current conservative form largely because of Trump's 3 appointments during his first term. He put Neil Gorsuch and Brett Kavanaugh and Amy Coney Barrett on the court, specifically because they were supposed to be reliable conservatives who would support executive power and originalist interpretations that favor Republican policy priorities. But even conservative justices have shown repeatedly they will not simply rubber stamp everything a Republican president wants to do, regardless of constitutional constraints. The court has ruled against Trump before on significant issues, and the pointed dissent in this case suggests the outcome is far from predetermined despite the 6-3 conservative majority. The connection to the broader administration chaos multiplies the danger of this legal challenge considerably. Trump is simultaneously fighting with his own speaker over spending bills and watching his protective media shield crack at Fox News and facing serious questions about his health and fitness and dealing with envoys caught on tape, coaching Russia and managing military operation controversies and watching members of his own party quit Congress. Adding a major Supreme Court defeat, declaring his purge strategy unconstitutional to this cascade of problems would powerfully reinforce the narrative that his presidency is collapsing on every front simultaneously and that his aggressive approach to power is backfiring catastrophically. The Doge and tariff connections mean the Supreme Court case is not an isolated legal dispute, but part of a broader legal reckoning with Trump's aggressive and expansive interpretations of executive authority across multiple policy domains. If courts are signaling skepticism of his power claims in multiple contexts, agency removal in tariffs and immigration and birthright citizenship, the pattern matters significantly for how future challenges will be decided. A ruling against him on agency removal could substantially influence how courts approach tariff challenges and other assertions of executive power that have been legally questionable from the start. The implications for the federal government are profound regardless of how the case is ultimately decided on the merits. If Trump wins, independent agencies effectively cease to exist as truly independent and become mere extensions of presidential will, subject to political direction on every decision. This would fundamentally transform how the Federal Reserve and the SEC and the FTC and dozens of other agencies function, making their decisions subject to direct presidential control rather than expert judgment, deliberately insulated from partisan politics. If Trump loses, the chaos he has already created through his unprecedented purge will need to be unwound somehow, and the legal uncertainty about which decisions are valid will persist for years as affected parties litigate. The contempt risks are very real if Trump refuses to comply with adverse rulings from the Supreme Court. He has shown willingness throughout his career to defy court orders he disagrees with, and his inflammatory rhetoric about rogue activist judges suggests he may not peacefully accept a Supreme Court ruling that goes against him on something this central to his governing approach. But defying the Supreme Court would create a constitutional crisis that even his most loyal supporters might find genuinely difficult to defend and would provide overwhelming ammunition for the authoritarian narrative his opponents have been building. The 25th Amendment whispers that we discussed in connection with health concerns become even more relevant when combined with legal defeats that suggest Trump is fundamentally unable to effectively execute his agenda within constitutional bounds. If his signature policies are being blocked by courts across the country, and his purge strategy is being reversed, and his health is visibly declining, the question of whether he can actually serve effectively becomes much harder to avoid, even for allies who have been defending him loyally through every previous crisis. That is the story of Trump erupting as the Supreme Court strikes hard at his FTC firing power and exposes the legal vulnerability of his entire agency purge strategy, a landmark case that could reshape presidential power for generations, and that represents the most significant judicial test of Trump's theory that he has virtually unlimited authority over every aspect of the executive branch. Drop a comment and let me know what you think about all of this. Should the Supreme Court overturn Humphrey's executor and give presidents unlimited firing power over independent agencies? Do you think Trump will actually comply if the court rules against him on the merits? And what happens to all the officials he fired and the officials he installed to replace them if his expansive theory of presidential power is ultimately rejected? Hit subscribe because this case is developing rapidly, with December arguments scheduled and a ruling expected that could fundamentally transform the relationship between presidents and independent agencies for generations to come. See you in the next one.